Welcome to our third session of World Arbitration Update, China Insight. So it's a great pleasure to have our third panel this afternoon. And I would like to give some information with respect to our esteemed moderator. And with that, but before getting into that, I'd like to give a big shout in terms of the topic that this panel will be addressing. It is the status and perspective of the Belt and Road Initiative, BRI, in international arbitration. As we all know, the Belt and Road Initiative is part of the economic policy and trade and also investment policy of China, but it has so far had influence in many countries that are included in the Belt and Road. And being from South America, but also from the US, I can see that influence throughout, especially in many countries in Latin America, but also in Africa and in Asia. And the question came to us in terms of its influence in international arbitration, because as we know, there's many dispute resolution systems within the Belt and Roads Initiative, not only arbitration, but special courts, etc. So on this occasion, we put together a panel to address those issues, especially in arbitration. So it is my pleasure to introduce our moderator, who is Professor Yu Dingdong, who is a professor of international law, and he is also the director of international economic law at the Department of the Institute for International Law of the Chinese Academy of Social Sciences. He's also the vice president of the WTO Law Research Society of China Law Society, and he is vice president of China's Arbitration Law Society. And I will stop there because I don't want to eat more of his time. So with us, you have the floor, Professor.
Thank you. Many thanks for organizer to introduce myself to all of you, and it's my very great pleasure to be here and to be invited to be the moderator of the third panel. And the organizer just introduced the background and the good meaning of the panel's topic. So at first, I would like to invite the panel's presenters, Murphy Mock, to have a speech. Murphy, please.
Thank you. Thank you, Professor Liu. Good afternoon, distinguished guests, ladies and gentlemen. I'm delighted to be here today to deliver an opening for this session's status and prospects of the Belt and Road Initiative in international arbitration.
我现在开的会就是昨天老费分享了嘛。
老费现在也算
是仲裁圈的人，整天参加仲裁会议嘛。
The Belt and Road Initiative, or the BRI, first launched by President Xi in 2013, is a grand vision that encompasses the Silk Road economic belt and the 21st century maritime Silk Road. It is aimed at enhancing policy coordination, financial, economic, and trade integration, and fostering connectivity between people and cultures. A decade on, the BRI has achieved tremendous progress. Cumulative economic engagement has reached over $1 trillion, while more than 150 countries have signed on to the BRI framework. These underscore the initiative's significant impact and reach in shaping global economic landscape. Given the BRI's sheer scale and complexity, disputes are bound to arise and have indeed arisen. These have been commonly resolved through international arbitration. In the next few minutes, I will seek to briefly reflect on some of the past and present issues in BRI projects, how arbitration has helped parties to navigate them, and what issues are on the horizon. One major challenge in BRI projects we have seen is the management of multi-party disputes. A single event can trigger claims across different layers of the contract chain, resulting in a multiplicity of proceedings involving parties ranging from host governments, lenders, project companies, to contractors, vendors, and insurers. Arbitration partially addresses this problem, as major institutions provide rules on complex arbitration, such as consolidation, joinder, commencement of single arbitration under multiple contracts, and concurrent proceedings. Arbitral institutions are also developing jurisprudence based on their experiences in managing such issues. This has, in some ways, mitigated time and cost concerns for commercial parties and the risk of inconsistent outcomes. Another challenge, especially relevant to dispute resolution, is the technical nature of BRI projects. Adjudicating parties' claims requires a degree of technical understanding of the industry and the projects themselves. A simple non-payment under a power purchase agreement, for example, can give rise to complex technical issues of how power plants operate and the underlying science of power production. Arbitration allows parties to select arbitrators with the requisite expertise to handle the case, giving them the confidence that they need and knowing that their claims are in capable hands. Due to the cross-border nature of BRI projects, resolving disputes also require experience and expertise in foreign laws. This may not be a straightforward exercise for domestic courts, especially in developing countries. In contrast, the identification and application of foreign law is a regular feature in international arbitration. Tribunals and counsel are familiar with and are well placed to handle multi-jurisdictional disputes. The third challenge with BRI projects is managing political risks within host countries. Many projects, which have long life cycle, are vulnerable to the impact of change in host governments. This often leads to consequential changes of tax and licensing regimes, as well as political instability and unrest. Treaty arbitration has played a role in mitigating these risks, protecting investors from expropriation and other unfair treatments. Bilateral investment treaties concluded by China with many BRI countries include investor-state dispute settlement mechanisms. This provides an avenue for agreed parties to seek recourse against host states in addition to their contractual remedies. These are just a few of the myriad challenges faced by stakeholders in BRI projects. While arbitration has so far been effective in resolving related disputes, it must continue to evolve in order to remain fit for purpose. Looking ahead, arbitration will likely need to grapple with, amongst others, three key issues. The first is harmonizing the dispute resolution framework. As mentioned earlier, BRI projects often involve many countries, each with its own legal system, practice, and pace of development. This has led to complexities and uncertainties in terms of legal outcomes. When disputes arise, identical issues could be treated differently under related contracts depending on the applicable law. Meanwhile, the degree of domestic courts' support of and powers to aid arbitration can also vary greatly across BRI countries. To further complicate matters, related arbitration agreements may not necessarily be compatible, preventing consolidation of proceedings and increasing the risk of conflicting awards. As the investment climate becomes more volatile, efforts at all levels to enhance predictability and consistency in the outcome of dispute resolution will be crucial. The second issue is the future impact of digital transformation. Technological advancement can revolutionize the way in which BRI disputes are resolved. One important trend is the development of online dispute resolution, which adopts distributed ledger technology and smart legal contracts. To ensure availability and quality of evidence used in arbitration, contemporaneous records can be stored, accessed, and verified on a blockchain platform. Once an award is rendered, funds from an escrow account can be automatically released to the winning party. These are just a few examples through which the efficiency of arbitration and enforcement of awards can be greatly enhanced. The third issue concerns the ongoing shifts of geopolitics. The US-China tension, regional conflicts, and economic sanctions in recent years have led to BRI disputes across the contract chain. As these issues gather pace, the number of disputes is bound to increase in the coming years. International arbitration has, to a degree, responded to these developments. For example, arbitral institutions have implemented sanction policies, including on disclosure of sanction-related information and payment arrangements to mitigate sanctions risks. But greater and faster adaptation is needed to ensure that arbitration remains a suitable means to resolve future disputes. Overall, the Belt and Road Initiative, with its vast scope and ambitious vision, has presented complex and multifaceted challenges. This has tested the resilience and adaptability of existing dispute resolution process. It will be interesting to see how arbitration, with its inherent flexibility and capacity for innovation, will adapt to the changing needs of commercial parties, technological progress, and geopolitics. On that note, I will now pass the time back to Mr. Liu, the moderator for this session, to introduce our panel of distinguished speakers. Thank you.
Thank you, Murphy. Sorry, I forgot to introduce the Murphy Mark. He is a foreign lawyer. He's from the Herbert Smith Free Hills. He's a very young arbitrator and very famous lawyer. In his speech, he introduced the Belt and Road background and very important meaning for the international trade and investment. And he gave us a lot of information and knowledge about the BRI challenge, risk, some important issues like the digital information transfer, geopolitics, especially he focused on arbitration and other tools, legal tools to handle the dispute and other legal issues in Belt and Road initiatives. Thank you for your very good speech. And all of us thank the organizers International Arbitration Update to give us the very important and valuable chance to talk about the arbitration, the relationship between arbitration and the BRI initiatives. In our panel, we have the three very famous arbitrators or lawyers to talk about this topic. The first one is Owen Ho. He is a partner, head of office, Pinsent Mansion, Hong Kong. Owen, please. You have 15 minutes.
Thank you, Mr. Neil. And thank you, Murphy, for that great opening. Basically, Murphy touches upon all the very fascinating and dynamic aspects in the Belt and Road arbitration that made many of our arbitral practitioners very interested in this developing area. I was involved in the first Belt and Road project back in 2015, which sadly became an arbitration. And one thing that I like about the Belt and Road footprint is, as arbitration practitioners, you get to travel to many different countries and jurisdictions that you never heard about or that you can barely find on the map. So it's a very interesting feature. And before I pick up some of the topics mentioned by Murphy and dive into it, I just want to raise one housekeeping matter. I mean, among our panelists, and with Mr. New agreement, we'll be opening the floor for Q&A after each of the panelists giving their speeches. So I will challenge you to bring up some interesting questions to sparkle into a dynamic discussions after our sharing. To contribute to today's panel discussion on the status and perspective of the BRI arbitration, I would like to pick up two key points just mentioned by Murphy. Is about the harmonization of procedural rules and also the geopolitical tensions that we are now seeing in more often in BRI arbitrations. And I would just like to make three observations as to going forward, how we can make arbitration an even more attractive options to all parties involved in BRI arbitrations or BRI projects. I'm going to start with one thing that I think the arbitral community is already doing pretty well. I mean, these days we see that many arbitration practitioners and arbitration procedural rules in the BRI projects have been paying a much better regard to the cultural and legal tradition differences between firstly the East and the West, and the many over 100 jurisdictions that the BRI project's landscape cover. I still remember when I first worked on the ICC arbitration for Chinese clients in one of the earlier BRI projects. It had taken us quite a while to explain to them all the different concepts about document production. I mean, someone like to refer it still as discovery, the purposes of like taking witness evidence, and the concept of testing someone's evidence through cross-examination. I still remember one of our witnesses was so nervous that like she was not able to sleep for a few days before going to give evidence in court. I mean, if we had this panel maybe 5 years ago, this will be what we are talking about. But fast forward to where we are these days, I think I'm very pleased that when we now have BRI projects disputes, whether mediation or arbitrations, I think the hosts, the arbitrators, and the legal practitioners are increasingly sensitive to all these cultural differences and are more willing to harmonize such differences and find common grounds in the arbitration process. These days, the arbitration rules provide a lot of flexibility to accommodate the different cultural values. It is not uncommon for arbitrators these days to give directions to, let's say, to keep document production to a minimum, to keep the testing of oral evidence only to a necessary extent. And when it comes to arbitration hearing, arbitrators quite often remind advocates, especially maybe from the States, not to be unnecessarily aggressive and dramatic. And they are more sensitive as to how some of the demeanor of Chinese witnesses, witnesses in many Eastern Asian countries may differ from the West, and how their credibility should be assessed. I mean, for example, it is not the Chinese party's custom to prepare very lengthy speech or documents or comprehensive records for arbitration, and they are in general more reluctant to express disagreement in meetings. But I think there is still, I mean, Murphy talked about looking forward the challenges. I think there is still one thing this arbitral community can do better, which is the procedural management and the parties' expectation on time and cost of arbitration. I mean, this problem doesn't only apply to barren road arbitrations, but is more important because of the cultural background that we are coming from. For arbitration to be the most attractive option for resolving disputes to parties in barren road projects, it has to be efficient and timely. I think we don't disagree with that. But I find that parties to arbitration very often after concluding or during the process are often let down by the duration and cost of arbitration. I mean, when was the last time that you had an arbitration that doesn't have delay or late application to amend memorials or had a further application to adduce like foreign law evidence or expert evidence in a wholly new area? Extensions of time, I mean, as practitioners doing arbitrations, we all take it for granted and sometimes it's unavoidable. But when parties subscribe to a set of arbitration rules with very specific time frames, it's quite difficult to explain to parties as to why the tribunal usually is still very accommodating in granting name fee and multiple extension of time. So priorities in this side of the world may be like given to afford the parties to have reasonable opportunities, more than reasonable, I would say, for presenting their case. But maybe for barren road projects, parties are expecting the arbitrator to be driving and managing the arbitrations with a greater degree of control. And that's something that I think we can do better at, and obviously it's a topic for discussion. And I mean, the last thing I would like to mention is what is raised by Murphy about the geopolitical situation that we are now facing. And given the very large footprint of the barren road projects and the large number of countries and jurisdictions involved, the interaction between the parties' arbitration agreements and the award and the arbitration process on one hand, and what each of the parties may be doing in the court of their home jurisdiction, the seat of the arbitrations, or even the seat of the enforcing court can be very complex and indeed very interesting. I mean, local courts can be engaged at different stages of the arbitration process. At the start, you'll have jurisdictional challenges, anti-suit injunctions. Throughout the process, local court can issue interim relief affecting the arbitration process. And after obtaining award, it can be a prolonged process of resisting enforcement and at various courts. Murphy mentioned about the need to involve more foreign law expertise. I cannot agree with that more. I find that over the years, I have been connecting with so many law firms from all different jurisdictions because of the need to obtain a piece of opinion as to what arbitrations means to a particular jurisdiction and how the award can be challenged and resized in many different ways. And recently I work on a barren road arbitration where one of the parties commenced court proceedings despite the assistance and the ongoing process of an arbitration. Although the arbitrator in our case has already issued interim relief prohibiting further steps to be taken in that domestic court. But because of some sanctions issues involved, the domestic court just don't give any regard to the arbitrator's order and just proceed with the cases regardlessly. So it can result, as we are already expecting, multiple parallel proceedings, and as Murphy mentioned, like conflicting judgments, conflicting awards, and conflicting outcomes. I have to say, I mean, those issues are very interesting for arbitral practitioners, but from the client perspective, is far from satisfaction. But I mean, this is something that we all have to live with, and we don't have a lot of control because of the growing tensions that we are witnessing in the world, which in a sense has affected how international arbitration and bilateral arbitrations will be conducted. So I will now hand over to Mr. Niu.
Thank you. Thank you, Owen's speech. Mr. Owen shared his very good experience and practices in the national arbitration areas. And the most interesting thing for me is you refer to harmonization of the international arbitration procedure and how to handle the different of the cultures and different country, different customers. I think it's a very, very complicated problem for the international arbitration. For example, the cross-examination referred by you in your speech is it's difficult for Chinese, because we have a very different culture with the Western culture. So I think it's very important for us to harmonize the difference between the different countries, different cultures, and we should support the model law of arbitration rules to harmonize the different countries' arbitration rules. So we can talk about this topic maybe after the sessions. And thank you, Owen. Next speaker is Teresa Zheng. I don't wish to introduce Teresa very more. We know her very much. She always is the core member of international arbitration areas, especially ICA Council, and a very famous arbitrator and the lawyers. She is senior counsel of Hong Kong and chambers of the Attorney Francis, NEO, QC, SC, GP. I want to let time to you.
Thank you, nonetheless, Dingdong, for that very kind introduction after you said you will not introduce me. What I would like to do in the time allotted to me is perhaps to ask you all to look at the topic again that we are to cover. I think it is not just about international arbitration. It is actually the status and prospects of the BRI in international arbitration. So it is really the status and prospects of BRI that we ought to be focusing in. But nonetheless, of course, in the context of the international arbitration. Now, when we talk about the prospects, we are looking at the prospects of the lawyers or arbitrators, or the prospects of the users, or the prospects of the completion of the particular project under a BRI project. So these are things that actually the topic is very broad. And actually, because with that in mind, I wish to move a little bit away from how international arbitration is done, but perhaps what other ways there are in handling BRI projects. I think it has also been touched by the former speakers. Now, the next thing I think to try and discuss this subject, we have to think about the types of projects, the types of contracts that would arise in BRI projects. Usually we think only of major infrastructure, but surely we are aware that it could include hospitals, building a school. These are all BRI projects because it is with a view to, and I think Murphy mentioned it, with a view to perhaps create a harmonious society, and indeed it aligns very much with the 2030 agenda of the United Nations of Sustainable Development Goal, that is to create harmony, peaceful coexistence, and so on. So I think the types of projects is very broad, and therefore mainly, I must say, with some construction projects in mind. Then the next thing to look at is perhaps the locale of these projects. Now, we cannot, I'm sure my colleagues cannot tell them where the projects are, because then it could be divulging the confidence of the arbitration. But we know that a lot of them are in African and the Central Asian states. And so one would expect some of these disputes arising from these areas. And of course, we know that the contractors, that is, or the concessionaire, are mainly Chinese companies, and that is the context I think we are looking at when we're talking about these types of projects. Now, I will mention a few things that I think we need to look at when we're talking about international arbitration, as my colleagues have. I think mentioning the multi-party, one of the very great difficulty that I think concessionaires and participants in BRI projects have is to ensure compatibility of their arbitration clauses. Compatibility in the main contract and subcontract arbitration clauses is actually very important, because without that, you cannot have consolidation. Now, one of the difficulties I understand from people who have been involved in these projects is that the main contract usually dictated in terms of terms and as a negotiating power by the employer. Therefore, it tends to be something that perhaps the Chinese main contractor or the Chinese concessionaire is not entirely familiar with. For example, using English law, for example, adopting an arbitration in a place that is not so familiar to the Chinese parties. Now, then the difficulty comes is the subcontractor usually tends also to be a Chinese company providing manpower. They would probably be happily dealt with through an arbitration in BAC, for example. But in order to ensure that the compatibility of the arbitration agreements are reached in the event of a need to consolidate, that will then necessitate the whole network of contracts involved in a BRI project to be looked at and work together so that compatibility is achieved, and if need be, to bring in a particular consolidation when arbitration arises. Now, on the question of substantive law, I think both Elvin and Murphy mentioned sanction as questions that could arise in their work. Now, one very interesting thing, and I think that's important to bear in mind, it's quite interesting, little story, and I cannot divulge the names of the countries or the parties. Country A has sanctioned a financial institution in country B. Country B's legal advice is that the contracts of that financial institution can no longer apply the laws of country A. So that, of course, may not be the same in every jurisdiction, but that is quite enlightening in terms of ensuring that your contract and the applicable law could then be dealt with sensibly. The next thing with international arbitration is, of course, just now we mentioned, may be generally governed or perhaps requested by the employer, as it were, in the construction contracts, is the seat of the arbitration. If there is a chance for Chinese companies to be able to negotiate, please negotiate within the time zone that you are familiar with, rather than to travel to Paris or to other parts of the world. I love Paris, by the way, huh? I would love Paris to shopping and eating and arbitrating as well. The time zone is very important choice. It's a small choice, but it's a very important choice because it will affect how you're going to handle the documents that you might need to dig up in the middle of the night in order to prepare for being cross-examined or cross-examining the other side in the middle of a hearing. And therefore, these are small logistics, but a very simple advice I would suggest would be that. A story I tell, again, relating to BRI, is when parties negotiate on the choice of the institution. Usually we have institutional arbitration nowadays. Ad hoc is more a historical feature. So they were negotiating a relevant institution to try and find the place, the seat for arbitration with the relevant institution. The story I heard is that, say, the employer would ask, the Chinese companies would suggest, okay, let us go to, and then again, I won't name the particular locations. They would say this particular institution, another one, another one. And there tends to be, in particular in African states, because they are unfamiliar with this part of the world, they tend to say no, because they say that these are local institutions. And therefore, they then tend to choose ICC Paris and London, for example. That is not ideal for Chinese parties, and therefore, in which case, I float to you another alternative that you may wish to consider, and that is to use the ALCO, the Asian African Legal Consultative Organization arbitration bodies. Now, I should not be saying that in a BAC event. BAC is your first choice without doubt, but when that comes to a situation where they say, I don't want to go to a local as in the sense of local to a particular geographic location, try that. Because the ALCO has 48 members, a number of them are African states, and they would therefore be familiar with this body, at least their government would be, and may be more amenable. Now, I say ALCO, there are 6 centers in the ALCO arbitral bodies, Cairo, Lagos, Nairobi, Malaysia, Tehran, and Hong Kong. So you can choose these 6 bodies, they have standard rules, and you can choose the ones that will be more suitable and more acceptable. So that's an alternative, because that's an intergovernmental organization, so you are free and you can move away from the arguments that it is a local body. Because the horror story I heard is that without agreeing to any of the institutions, local institutions, what the parties then end up agreeing to is ad hoc arbitration in a particular location in Africa that they have not even heard of. And it is very scary if you think of your arbitration ending up there and you don't even know how to handle it. So I float that as an idea for you when you are negotiating your arbitration clause. Now then, let's move on to the types of clauses that are typical in BRI projects. I think, as you can glean from the discussions from Murphy and Elvind, they tend to be escalation clauses or multi-tiered dispute resolution clauses, in which you start with usually the site trying to agree. If not, you go to the senior management. If not, you go to mediation. If not, you go to adjudication. And if not, you go to arbitration at the end. Now, for other projects, I would advise, for other contracts, I should say, I would advise entirely against it. But for construction, my own experience is that sometimes these work if you've got them drafted properly and if you manage them properly. It works because in a long construction project, you need decisions to move on. You cannot forever be writing letters disagreeing things or forever be reserving your rights on a particular dispute. So at least using these steps, you have something resolved very quickly, albeit on an interim basis. And if it is on an interim basis, it then has the benefit of being reviewed later. But you move on with the project because there's nothing more scary. We're looking at the prospects of BRI in international arbitration. You want the prospects of completing the project. So escalation clauses possible, not bad idea in construction disputes, provided it's drafted properly. So you need good advice good lawyers to draft those clauses in order for them to be used. But having said that, I understand that because with a view to try and resolve the disputes there and then, there is growing use of expert determination. As I heard yesterday and I've heard previously, people are encouragingly using that as a process. Now, those who are in the construction industry would know that you would have the engineer's decision, the contractor doesn't like it, and then you have to swallow it and move on. So therefore, the expert determination in a way very quickly reviews the engineer's decision and provide a basis for parties to move on. So that is, again, not a bad idea. Again, identifying, narrowing the dispute. It is all these processes involve a very clear identification and delineation of the issues that you refer to each of these processes. All right, so the expert determination is something that that one should bear in mind. Now, nowadays, I think, well, not nowadays, I think, in fact, just yesterday, I was asked a question about the status of such expert determination. I think in very brief terms, it is contractually binding, and it's interim basis. It's interim until you seek to review it at the end of the day. And of course, it depends how your contract and how your expert determination clause is drafted, but that's the idea. Of course, you can make it final and then it's not reviewable, in which case parties don't like it. They always like to have a chance to fight it all out in an arbitration. So that seems to be very much a trend. The other thing that will assist in reducing or narrowing the disputes in an international arbitration is the use of dispute sports in construction projects, be they, whether you call it DAB or DRB. These dispute sports tend to have attraction of actually preempting the disputes. I used to describe them as like people who are smelling whether something is likely to go wrong and then nip it at the bud. And so therefore you may have a chance of actually preventing the difference becoming into a dispute. So it is part of a dispute avoidance measure. And construction contracts have that. I think FIDIC have those terminologies, but it is not used enough because contractors tend to think they're costly, but they're not. 3 persons once a month or once every 3 months, fly them to the project and 2 days meeting, compared to a long drawn out arbitration. It is entirely worthy. It's really good value if you again manage it well and use it well. So consider using DRB, DAB in your projects. Do not think of the immediate cost, because disputes will definitely arise during a construction project, and it's a matter of avoiding them and managing them. The third thing I'd like to mention, I don't talk about adjudication because in the interest of time, but let's talk about mediation. Mediation has its benefits, and in fact, if we are looking at BRI, mediation should be promoted more than arbitration, because with the idea of BRI, 共商共建共享, which is mutual share, mutual build. Thank you, building and sharing and enjoying. That really means that you have to have a collaborative effort. And using mediation to settle a particular dispute as and when it arises, nip it at the bud, and you move on with the project, keeping good relationship. It can be done on an issue-by-issue basis. You don't have to wait till the end. So your drafting of escalation clauses will allow you to use these mechanisms to achieve what I would prefer to call dispute avoidance, not so much a dispute resolution. Now then, I know that Hugo will be talking about investment, and let me then share another story, again without divulging any parties or any jurisdictions. 2 Chinese companies wanting to invest in a particular continent. All right, I'll have to keep it as brief as a country in a particular continent. And both of them first go to Hong Kong to start their, do their IPOs and corporation structure. One of them then went to the Netherlands to then set up the SPV in order to invest in that particular country. The other one goes directly from Hong Kong to that particular country. The same measure or the same acts were taken by the government in that country that causes, allegedly, according to the companies, damages to them, and they therefore are now dealing with it in the country, within that country. Now, if this matter fails in being resolved in that country, then it might have to end up in investor-state disputes. Hong Kong, for example, doesn't have Hong Kong can enter into bilateral investment arrangement with other jurisdictions, but we don't call it treaty because we're not a country, as you know. We're one country, two systems, but we're allowed to enter into that. And Hong Kong has about 22 of such investment protection arrangements with other countries. Hong Kong doesn't have with that particular country, but Netherlands have with that particular country. And therefore, the protection that would be afforded to the one that uses Netherlands to establish an SPV to go to invest become more useful. Hopefully, no one wants to go to ISDS unless absolutely necessary. Taking on a state is a brave act, and you don't do it lightly. So, but you need that protection, and that goes to the planning of any BRI project right at the beginning. So I think my focus, as you can see, is more on dispute avoidance. And I think if dispute avoidance is done well, then the status and prospects of BRI, whether in or not in international arbitration, will be very good. Thank you.
Thank you, Teresa. Thank you for your very valuable and important speech. She has talked about the huge information and knowledge in the modern arbitration areas. But the most interesting things is 3 points. The first one is she focused on and emphasized the close importance to the B&I initiatives, especially on the infrastructure and other very huge deals, contract clause, very important for the arbitration's result. I mean, the arbitration result mostly is depend on your own contract clause. I think it's very important. And the second point, she focused on the seat of arbitration or the choice of the arbitration body. I think it's also important, especially for the Chinese enterprises. They joined in the very huge infrastructure building and a very long time to project in B&I initiatives. So arbitration body's choice is very sensitive for Chinese enterprises. I suggest the Beijing International Arbitration Center is the best one for your choice. And the most interesting point is she focused on the mediation. I think it's the Chinese preferred styles mediation. We have a very good, very old tradition for the mediation. She emphasized the mediation's importance to handle the legal dispute in the B&I initiatives. She also talked about the new items and the new topics, for example, DRB, expert determination, DAB, and the BIT's use in the investment dispute settlement. A very huge, large information and knowledge. Thank you. Many thanks for Teresa. We can transfer to the last speakers in our panels. Hugo Perincano. He is international arbitrator and a legal specialist, IIURIS. Yeah, goes to you.
Thank you, Mr. Liu. And let me just begin by expressing my appreciation to WOW, Jose Antonio Ribasian, and of course, BIAC for the invitation, not only to share some remarks with you, but to share this panel with my colleagues who have made such interesting presentations. So it's an honor to be here along with you. So I want to focus on investor-state dispute resolution in the context of BRI. Now, China is the fourth largest source of foreign direct investment. This means outward flows of Chinese investment to the rest of the world, and the second largest recipient of foreign direct investment. And China's role as one of the main sources of FDI in the world has increased, and it is bound to continue to increase thanks to its Belt and Road Initiative. BRI projects have, as Murphy initially said, they are high value, multi-party. They always involve the state, the interests of states. They involve very complex projects and transactions, as infrastructure projects always are. But as Teresa was saying, there are other types of projects that go along with the main infrastructure projects, such as building schools and hospitals, power plants that support the main infrastructure projects. So they are highly complex. Murphy referred to the multiple parties involved: contractors, subcontractors, suppliers of goods and services, lenders, financiers, insurers. But they also involve multiple stakeholders beyond the parties that are involved in these projects and transactions. I referred to already to the states. So certainly the Chinese government, not only because it is its initiative that we're discussing here, but also because state-owned enterprises play an important role in developing these projects, both as contractors, as developers, but also providing financial aid, financing the projects themselves. So it has that other interest as well, as opposed to many other governments. And there are also other stakeholders that we, in discussing investor-state dispute resolution, we often tend to overlook. For instance, the local communities where the projects are going to be built. The local communities where railways or roads are going to pass. The people that have environmental concerns, so not only the local communities, but also non-governmental organizations that are interested in preserving the environment. So again, there are these other stakeholders that are involved in these huge projects. And Murphy also touched upon, the cultural, political, and diversities in terms of where these projects are taking place. just the sheer number of countries around the world that are now either signed up or signing on to the Belt and Road Initiative. This, again, it provides for a highly complex environment at large. And given the sheer breadth of the projects, as Murphy again and Alvin, I think you touched upon as well, is that disputes are bound to arise. They are arising, and we need to think about how to best resolve, hopefully, as Teresa was saying, how to best avoid disputes altogether, but nevertheless, disputes will arise. We'll have to figure out how best to resolve them. In this context, China has an extensive network of international investment agreements. If I'm not mistaken, it has around 145 bilateral investment agreements, the majority of which provide for investor-state arbitration as the means of dispute resolution. There is a first generation of agreements that do not provide for ISDS, or investor-state dispute settlement, at all. But a second wave of investment agreements that provides for traditional, or what I would say traditional ISDS, and a more recent wave, or a more recent generation, third generation of investment agreements, where China has taken somewhat of a more cautious look at investor-state dispute resolution, and has begun to include some of the advances that are being discussed in international fora. But what's important to note is that against the somewhat still recent backlash against investor-state dispute resolution, China has continued to support inclusion of ISDS in its treaties. China, at the UNCITRAL Working Group 3, which is the group at UNCITRAL that is looking at ISDS reform at large, China has expressed support for ISDS. China, more recently, for instance, has requested to accede to the comprehensive and progressive, the CPTPP, the Comprehensive and Progressive Trans-Pacific Partnership, which contains, includes ISDS, and that again is in line with China's positive view of investor-state dispute resolution. Now, China has been a critic of the traditional while it supports ISDS, it has also been a critic. It has also joined other countries in its criticism of the traditional ISDS. China, for instance, has joined other countries, perhaps importantly, in the lack of corrective mechanisms in ISDS and the lack of stability and predictability of the system. So it has, I wouldn't say put forward, but it has, it supports an idea that is by no means new, but the idea of establishing an appellate mechanism similar to that of the WTO, building an appellate mechanism into the into ISDS, investment dispute resolution system. It is still, a difficult idea to implement, but what it means is that China doesn't only have a positive view in terms of ISDS, but is also it is proposing ideas as to how it can evolve in the somewhat near future. So in terms of what the prospects might be is, well, China, of course, as I've discussed and my colleagues before me have discussed, plays an important role in the context of ISDS. And especially now that ISDS is changing, it is evolving, it is subject to an important multilateral reform, it can continue to play an important role. And that China has a significant interest, in my view, in ISDS, not only because it is the source of investment flows generally, but because BRI is all about outward investment flows. Again, because of the importance of participation of Chinese state-owned enterprises in the developing and financing of these projects, China should have an important, should continue to play an important role in how ISDS evolved. But also because, again, in the backlash against investor-state dispute resolution, if we take a look at the map and where the economic belt and the maritime Silk Road will go through, and as it has been expanding along many countries, well, Chinese investment is flowing into countries in Africa, in Latin America, that have been at the forefront of this backlash against ISDS. So it should be not only of interest to China, but of interest to the rest of the world. What is China's position, how it will evolve as BRI continues, as BRI progresses. And the last subject that I would like to touch upon is Teresa made emphasis on mediation. And she made emphasis on mediation in the context of dispute avoidance. And Mr. Liu as well, he said, this is China's preferred method of dispute resolution. But I would like to give it a little bit of a spin, because ultimately we've talked about arbitration throughout the morning, and two of my colleagues before me talked extensively about arbitration. But I've always been a proponent of investor-state dispute resolution, and specifically of investment arbitration. But ultimately, I think it is a losing proposition. In my view, a successful investment is worth so much more than the most successful arbitration award. So by the time that the parties are involved in arbitration, if the investor wins even an important award, I think it has lost a good business proposition, a good business deal. And in contrast to the state, if a state wins the award, well, what that means is that it doesn't have to pay damages, but more importantly, what it means is that most probably it has lost the investment. So ultimately, when we are in arbitration, however it turns out, it is a losing proposition. And in this context, mediation can be an alternative, not only for dispute avoidance, hopefully, but in order to foster successful investments where problems have arisen. And again, as my colleagues have said, and I referred to it in my initial remarks, disputes are bound to arise. There's no question. The number of transactions, the number of projects, the complexity, the number of parties involved, disputes will arise. But even where they have arisen, if mediation as China's preferred method of dispute resolution, if it can be turned into a means of making investments successful or making them successful again, I think that will go a long way. In my experience now of close to 25 years in ISDS, I have not seen mediation almost anywhere. There are a few conciliation cases in the context of ICSID, a few others out there, but it has not been used as a tool. And for many years, I was Mexico's lead counsel in these types of arbitrations, and many of them could have been resolved to the benefit of both parties, to the benefit of Mexico as the state, and to the benefit of the investor, if a solution could have been found that would turn what was a dispute into a successful investment. And I think China, just because of its tradition, of its culture, and as Mr. Liu said, of its preferred means of dispute resolution through mediation, it could play a very important role in the context of BRI as we see, the prospects of ISDS generally as BRI progresses. Those are my remarks. Thank you.
Thank you. Thank you, Hook. Thank you for your very important and interesting speech. In his speech, he talked about a lot of the complicated elements in BRI initiatives, like environmental concern, labor rights, and cultural difference, and some other law difference, other things. The most important for me is you talk about the exit system. You said China is a supporter for the exit and ISDS systems reform. We have delivered our agenda and our advice to the United Nations Trade and the Law Committee. We also support build a corrected system, like you have said, like a party body of the WTO. But unfortunately, WTO-AB has been paralyzed by our American friends, So but I always support we can build a new correct system in SDS. And you talk about the CPTPP. China have delivered our application to join the CPTPP, which is a very important trade and investment agreement in recent years, have a new high level trade and investment rules and dispute settlement rules in CPTPP. We have reached a lot for a long time, and we wish we have a good end to join in the CPTPP. And in your last part of your speech, you refer the importance of the mediation. You attach importance to the mediation in, especially in dispute, investor-state dispute. I agree with you in this point. And because the time limit, I don't say a lot of. And we have closed our speaker speech, and the next one is the Q&A time. If you have a question, you can raise your hands. No friend? No problems, friend? Yeah, good. Your turn.
Can I just to sparkle the discussions, following from what Hugo said, let me again share another story. Investment arbitration that went on for about 9 to 10 years, exit. The host state won. And then about a few months after that, the investor started to negotiate with the host state again to continue with the project, probably in other terms. Now that to me is a classic case that had they used mediation right at the start, they would have renegotiated a deal that will suit, I mean, you may not like it, the host state should not withdraw things or the investor should not want more, but whatever, they could have resolved that instead of having 10 years in arbitration and now going back and renegotiate another deal. So I mean, that I think, you know, when you mentioned it's not used, it immediately reminded me of that particular story.
My name is Jose Antonio Rivas, and I have two questions for you. The first question is in the context of UNCITRAL, the UNCITRAL proceedings and negotiations, to the extent that you have privy information in terms of the Chinese position concerning the appellate facility, it would be very interesting to learn its logic versus, for instance, the logic of other countries that may be in favor of the multilateral investment court, or versus the logic of some states that may be against both the appellate facility and as well as the multilateral investment court. So that's one question, because there's a lot of interesting state perspectives in terms of investment arbitration and public international law with respect to those three positions. No, no reform on that matter, the appellate facility, and the multilateral investment court. So that's question number one. And question number two is on mediation. I understand that culturally, and as we saw this morning with Madame Zhao, culturally, China has almost an ancestral tradition of mediation that goes very, very long, for a long time. And I understand that mediation forms a almost intrinsic part of Chinese legal tradition. I could understand how, for instance, when a foreign investor would be suing the Chinese state, mediation would be an option because it's part of the Chinese tradition. But the question is how to sort of modify the intrinsic ways and means that other legal cultures have as host states, where they may be somehow more afraid of mediation in investor arbitration. And what happens in other countries is that there may be willingness by some or logic to be willing to do a amicable arrangement, but ultimately the public officials are very much afraid of agreeing to a mediation or an amicable agreement if the cultural, if the legal culture is not there. I have a few examples of states that have been mature enough to get to an amicable agreement. One case in which I the former law firm that I was in, I was able to represent the investor against Canada, and in that case, Canada agreed to settle because the measure was actually called the expropriation decree. So it was quite obvious that there was expropriation, and that was it. But most of the countries are very reluctant to do mediation or get to a settlement. So what would be, from a Chinese perspective, what would be your advice in terms of how to somehow influence the legal culture of other states that may be reluctant to get to an amicable settlement because of the fears of being personally responsible for those kind of amicable settlements? Thank you.
I'll try and answer the second. The first, of course, I am not able to comment. I'll try and answer the second in this way. If we're looking at BRI projects, African states, Asian states mainly, at least for now, of course, it could differ. These states actually have a very similar culture of conciliatory, try and settle rather than to, quote unquote, fight it out in the court. So less litigious type of nature. I was quite surprised until I speak to some of the African friends, because we do training for government officials in Asian African countries. We, that is, in my capacity as the Asian Academy of International Law. So when I realized that they were very conciliatory, that it sort of reinforces my belief that it can be something that can be looked at. So I think the culture is not the concern. What you mentioned about government officials would be afraid to settle because of personal accountability, etc., that I think is not the legal culture. That I think is universal. I think everybody has that concern. Every country in the world, be they what one would call the very litigious states or the sort of more conciliatory states. So that concern, I think, can only be overcome through training. Training in the sense of letting people appreciate how it works, knowing the benefits, and actually devising a system within a government to ensure that a decision made in a mediation by a current government would not be used by a later government to go and attack on the officials to deal with it. So something sort of, I think, this is my thinking, that is divorced from the overall political changes in government, election, and all the rest of it, to ensure the integrity of that process is preserved. The Asian Academy of International Law have been providing training on investment mediation since 2018. The first few were actually with ICSID, and very useful. I think people learned a lot from that, and we intend to continue to do that, and very supportive of the UNCITRAL Working Group 3, the mediation guidelines and draft clauses that came out last July, I think, yes. So I think it's not easy. I think the target should be explaining how governments should be able to accept it. Investors generally are more amenable to mediation, but I understand, we fully understand the governments may be less willing, and that I think is a lot of people doing a lot of work trying to do capacity building as well as devising systems.
Yeah, I want to say more on the second question. Mediation is a lower cost, and lower practices, especially on the legal professional. Yeah. We also have the Singapore Mediation Convention now. This convention can push the agreement, settlement through the mediation can be enforced in some countries. Especially, I emphasize the BRI, the initiatives, including mostly developing country. They care about the arbitrations cost, arbitrations practices. My colleagues many developing countries told us. The international arbitration area is a small circle, very small circle, almost from the Western country. So I agree with what Teresa said, especially in Asia, almost in Africa, especially developing country, they prefer to choose the mediation to handle the disputes, investor-state dispute, commercial dispute. And the Singapore Convention can push these efforts. Yeah. And the first question for you.
Well, let me briefly touch upon the second question as well. Teresa has given us many stories, and let me just share one with you. And I think it goes to your question as to what does settlement mean? And where the investor wants money, a settlement in terms of a monetary compensation. I don't think that mediation is going to help a lot. And at least in my experience, investors tend to look at it as, it only adds to the time and cost. Because if mediation goes nowhere, then you're stuck with arbitration, and it only adds to time and cost. But I was involved in one case where actually the government proposed a settlement option that could have been well mediated, that involved rescuing the investment. So we were in the middle of arbitration. There was the company that was involved was bought by a larger company, and they said, let's discuss settlement. Long story short, they said, we're suing Mexico for $60 million, but we'll settle for $20 million. And what I told my boss, the minister at that time, I said, look, it's very difficult for the government just to hand out a check and say, okay, we're saving $40 million, just handing a check of $20 million as a settlement. And it brings all the problems that Teresa was referring to, accountability and so on. But I said, it would be quite different if the government, instead of handing the investor a check, that they will go and then invest elsewhere. Why don't we, supply $20 million worth of, this was a waste concession, so dump trucks or a landfill. So it's easier for the state government or the provincial government to say, okay, this will go not to the investor, but to the concession. And this will be the landfill. And it's worth however much a landfill of that size is worth. And so many dump trucks or waste collection trucks. So, you add up, I don't know whether 20 or 15 or however much, but instead of handing over a check, the government invests and creates an interest into the investment project. And the investor, you can also say, okay, we'll chip in 20 million, but you have to chip in 20 more million. And we'll make this into a larger concession. So I thought that was an interesting idea. We talked to the municipal government. They said, we could work something out. We talked to the state government, or what would be in Mexico, a province, and they said, I think we could make it work and we could find funds. And the federal government was involved. Ultimately, the investor, because they had, their mind was set in arbitration, they had thrown in the towel as far as the investment was concerned, and they were not interested. They ended up losing the case. Mexico ended up losing the investment. And like I said, it was ultimately an investment proposition. But I think it takes a different mindset as to how you look at, what is possible. Not all disputes can be settled in this manner. or can be mediated. Now, a mediator can take a look objectively, hear the parties and say, you know, this is, there will be no check, but let's turn this into a successful business that's interesting for the state, that's interesting for the investor. And I think mediation can go a long way in that respect. Now, just briefly on your second question, of course, I'm not as qualified as my colleagues. Yeah, as to the Chinese position, but my understanding is China still supports arbitration and still supports investors participating, for instance, in appointing arbitrators. And that is why it is thought of an appellate mechanism as a second tier, as opposed to an investment court. Now, an investment court, my own view is that it will not happen. I think the prospects of an appellate mechanism, as you know, as complicated as that may be, it has better prospects than an investment court. An investment court can only be successful if it is truly multilateral. And even, you know, Chinese tend to have a very particular view of the long term. Long term in Chinese terms is very, very, very long term. An investment court will happen in the very long term in Chinese, you know, terms. So I don't think any of us will be around here to see it happen. But an appellate mechanism, it might, and there is a legitimate concern about, you know, uniformity of decisions, about predictability, about correcting certain mistakes, that I think it faces a better prospect.
Yeah, I just want to quickly reflect on the example given by Hugo on mediation. I think where officials and individuals of governments are involved, sometimes in resolving a dispute, it's actually an easier option and in fact lazy option for them to go to arbitration. And in the context of assessing the prospect of mediation, I think obviously finding the people and the group with the right authority and with the right mindset to make the decisions are always challenging. But having a good understanding of the government system and their internal procedures will almost give you a good sense as to whether it's an appropriate case for resolving it via mediation.
Thank you. Murphy, you want to say something? A little bit.
I think just on mediation, the other thing that to bear in mind is I think that there needs to be work to be done internally within the government to instill in positions where important decisions can be made to encourage the adoption of mediation, people with the expertise and experience to do the advocacy internally within the government, in addition to the kind of external training that Teresa has mentioned. I think, you know, work needs to be done in parallel in order to promote mediation as an alternative to arbitration as a dispute resolution mechanism.
Yeah, thank you. The time is flying fast. It's a time to close our panel's discussions. Thank you all the panelists for your very valuable, important speech on the arbitration and the BRI initiatives. And thank you for your comments and your questions. Thank you for the audience and the attendees for your time. Thank you.
站近一点。